Good evening. This is Laws 19038, Planning and Environment Law. This is week number 9. My name is John Milburn, the course coordinator. This week I want to talk about a few things, including some brief feedback statements in general terms about assignment number 1 or assessment number 1, some commentary in relation to what is expected in assessment number 2, and some other issues, and rounding off with environmental impact assessment. But firstly, could I mention that we do have now the opportunity to have you provide feedback to me. This is an anonymous way. Click on the big red button to let us know what you think about the course. We'll use the information to provide us, that you provide us will help us in terms of enhancing the overall course design, the way it's delivered, and the outcomes that are proposed and sought as part of the course. So it is really important, and I'd appreciate it if you would provide that feedback. The university does expect a number of things in terms of the way in which the courses are presented and structured. It is meant, of course, to be a positive learning experience, and it's designed to ensure that your potential is met by fulfilling a few key outcomes. We want to ensure that you have the opportunity to develop your appropriate skills and knowledge and attributes during the course. Now, a big part of that is making sure that, in my case, I'm able to provide you with clearer statements about what it is that I expect and what needs to be learned in order to succeed in the course. The course is designed to be collaborative, and we encourage students to continue to collaborate primarily through UCrew, but also through study groups, emails, Moodle to a lesser degree, and through these interactive Zoom sessions. So, and what we want to do in the assessment piece is provide you with an opportunity to demonstrate that you have acquired these skills and this knowledge and these attributes that we're trying to enhance. I will provide you with a short video from Professor Scott Bowman as to the importance of course evaluations and the need for constructive student feedback. So I look forward to receiving that feedback, and I encourage you to provide that feedback anonymously as soon as possible. Now, tonight's topic is about environmental impact assessment. I will round off with that, but before I do, I just want to talk about the way in which I've structured some of the Zoom sessions. Each week I provide this form of interactive live session. I supplement it with videos which are designed to be more a traditional classroom type learning experience, where I critique and summarise the chapter on baits, which is relevant to that video. And the third thing is that I provide videos which are, if you like, meant to be very practical, dealing with industry experts. And the 4 videos that I would urge you to look at are, firstly, the video by Phil Jeston, which deals with environmental impact assessment. Then, of course, we have the video from Roger Curry, the environmental activist, who talks about the role of experts and his involvement in litigation. It's very important from a practical point of view to determine what's relevant to building a case and presenting that case, the role of experts, etc. Some of the risks associated with becoming involved in planning and environment court legislation. Then we have the expert commentary by Rod Litster, QC, which deals specifically with the Predajon case, and I do trust that you looked at that before presenting your answer on Predajon. It really was a very valuable resource, and wonderful of Rod to donate so much of his time to assisting in the process. And finally, of course, and by far least, we have the commentary in relation to courtroom etiquette and courtroom practices by Judge Morzone QC, who was, at the time that I was kind enough to have, or he was kind enough to accept my invitation, was Dean Morzone QC at that time. All right, so I mentioned that we have this excellent video by Phil Jeston. That was prepared by me last year, and it relates specifically to environmental impact assessment. It is supplemented by what's in Chapter 10 of Bates, and the idea of having Phil Jeston provide his commentary is to provide some commentary about what it's really like in practice. And I urge you to look at this video from Phil Jeston of GHD Australia. He's an environmental scientist with more than 15 years' experience in, amongst other things, the assessment of environmental projects and the writing of reports that are necessary for consideration in that regard. He has worked on a number of large industry applications and is a published writer at QUT and for the Queensland Environment Law Association. So I would urge you to have a look at that video by Phil Jeston in the context of what we're doing this week. Now, before I make some brief comments in relation to environmental impact assessment to supplement what Phil Jeston has to say and what's said in Bates, I will talk about the two assessment pieces, both worth 50%, and the first deals primarily with the Predajon case and some aspects of planning law. The purpose of providing that exercise for Predajon was to enable you to consider and interpret a decided case. And during the course of your reading, what we hope is that you will read it in the context of real-life litigation, and reading a case provides you with an opportunity to look back at what the judge considered to be important and how the judge went about making, in this case, his decision. Many of you will have noticed the expert evidence which was adduced in that case, and many of these planning and environment law cases really do revolve around the quality of the expert evidence which is produced. Now, many of you will be involved in environmental law from a practical perspective in either being an expert and providing this evidence in court, or preparing reports that are preliminary to that court case, or indeed perhaps even being a party to the litigation as an objector, or representing a counsel, for example, or a property developer, or it may be that you'll be practicing as a lawyer in presenting that case. So all of those things are relevant in the context of reading that case as a decided case. In this course, what I've attempted to do is essentially work backwards. Now, let me explain that. From the outset, we looked at, if you like, the broad, big picture. So we started with environmental law at an international level, and then we talked about how that environmental law at the international level permeates through Parliament into the making of laws, both at the Commonwealth level, say the Environment Protection and Biodiversity Conservation Act, or EPBCA, or at a state level, say in Queensland, the Sustainable Planning Act, or the Vegetation Management Act, or the Environment Protection Act. So these things are at that level where the governments have adopted policies and created laws around those policies. But as we discussed, legislation is not the only way in which laws are made, and the case law is also a part of our law, and that's where the Predajon critique comes in. But looking further down, we're now at that stage of the course where we're talking about the evidentiary side of what is presented in a court case. As I mentioned, the experts have a powerful role to play, and the opinions and the reports that are prepared by experts will go a long way to either winning or losing a case. And an environmental impact assessment is the most important of the various processes which is used as part of the evidence in a court case. So that's why we're talking about environmental impact assessment, and you'll see in the second assignment piece there's a big emphasis on the way in which environmental impact statements, which come about as a result of the assessment, have a bearing on the way in which executive consider the decision-making process. So the Ella Bay Resort project is all about you considering the way in which the report, the assessment, is considered by the executive. Now, if we go further down into the assessment number 2, you'll see that we have this question about Fraser Coast Regional Council against Byrne Brothers. Now, the thing about this which makes it special is that we've taken it almost right back to the start, in that while it's not prospective litigation, it's real litigation, it has started. Unlike Predajon, this litigation hasn't finished. It's real time and it's real life. And your role is to look at this current case and try to make an assessment about what has happened so far and what you expect might happen into the future. So in that sense, there is no end to this story. It's not like Predajon where you know the end. This is one where the end is yet to be written, and you have your opportunity to assist by proffering your opinion about how it might end. Now, in writing about this exercise, I would urge you to consider it perhaps from the perspective of a litigant in the proceedings, from the perspective of an advisor to one party or an advisor to the other party, or from the perspective of a judge looking at the evidence and making a decision, or better still, all three or all four. Look at it from the perspective of the litigants, look at it from the perspective of the advisors to the litigants, look at it from the perspective of the judge, and provide some commentary. As I said in the outset in the course, it's not necessarily going to be the case that there's a right or a wrong answer in any of these legal issues. It's the way in which you argue the fact which is important. But it's not argument for the sake of argument. What are we really looking for? In this case, in the Fraser Coast Council case, the parameters are quite broad. The intention is that you look at this from a practical perspective and see what life is really like if you're going to be practicing in environmental law. I mean, it's kind of easy, isn't it, to look back at what a judge decided and say, well, this is what the judge decided and this is why. That's easy enough, but it's a much more difficult exercise to take some raw clay, so to speak, and then mould something beautiful out of that raw material. And so here's your opportunity to mould something out of this yet to be decided case. Have a chat through UCREW, discuss through study forums, in a sense, collaborate constructively with each other so that you can exchange some ideas. I'd really like some interaction in relation to the work that you do preparing for this second assessment piece. All right, so in the Fraser Coast Regional Council case, you have your opportunity to consider what's there and make some comments about it. Well, how do we do that? What's the best way to do it? I'd recommend that we look at legal issues always from first principles in this sense. Remember at the start I talked to you about the MIRAC or the IRAC method of legal analysis? Well, the same applies here. So if you're trying to make sense of the Byrne Brothers case, think in terms of, well, how do lawyers think? Well, firstly, M, material facts. We try to identify what are the facts that are material to this case. We gloss over or ignore those facts that really don't matter. Whether we're talking about a parcel of land that's 100 acres or 110 acres doesn't really matter. We're talking about small, large, whatever parcel. But what is the material fact here? And there might be a few material facts. So the first thing you need to do is zero in and determine what those material facts will be. That's the M in MIRAC. The I in MIRAC is what are the issues? All right, so we've determined what the important facts are. The next question is, what are the important issues? What's really important in this case? What is it that the court needs to concern itself with in determining this? If you're looking at it from the perspective of an advisor to the litigants, you're asking yourself, what is important that I put together by way of evidence which I can present to a court to convince that court that the decision should be in favour of my client? So you've really got to think about what are the important issues. That's the I. The R in MIRAC stands for rules. So we need to identify what are the important rules. Those rules could be through international law, they could be through Commonwealth legislation, they could be through state legislation, They could be through state planning policies, regional plans, planning provisions through the executive level, or it might be in terms of case law. So all of that is what we would call the law, the rules, if you like. So it's a matter of extracting what are the important rules. And you have your opportunity in that Byrne Brothers case to think about, okay, what are the important rules? Do I need to look at or consider Commonwealth legislation? Do I look at state legislation? Do I look at case law? What's important and what will the court consider are the appropriate and relevant rules when considering a determination to this case? So once we've determined the material facts, M, the issues, I, the rules, R, we get to A. A stands for application. How do we apply the facts and the issues in this case to the rules? What is the way that the rules are interpreted when considered in the context of this factual matrix? Ultimately, we come to the C, which is the conclusion. And here's where you get to write your answer. So you get to write the end of this novel. What you can do, if you like, is go back in a year's time, have a look at what's on the website, and see if your answer about the ultimate conclusion matches what actually happens. So it's a prospective question. And if you like, as I said, we started off very broad and theoretic. Now we're becoming more and more practical. Tonight we're at the stage of talking about the most important evidence which is presented in an environmental application or case, which is the environmental impact assessment. And then through this next assessment, we're talking about putting yourself in the role of an assessment manager, and then finally putting yourself in the role of an advisor in relation to a case that's not even decided yet. Okay, so that's what we're trying to achieve through our assessment process. Speaking of assessment, let me take this opportunity to provide some feedback, if you like, some insight as to how I go about marking an assessment piece. And I think what I do is probably similar to what most course coordinators would do. I know I run the risk of being superficial with this, but the way your paper is presented is really important. It creates an enormous first and important impression. And it's important that your presentation is professional. If you're practicing in a field of environmental law or planning and environment law, you might be charging $400 an hour. So if you're doing that, people want to see something that is accurate and neat and professional. And there's really no substitute for it. It's just got to be right. Look, it's so easy to fix things when you have, through the word program, the little green squiggles and the little red squiggles and little blue squiggles. Sorry to use the non-technical terms, but that's what they are. And that will be a guide to an issue in relation to spelling or grammar or some other issues. So take note of that. It just amazes me constantly when people present a paper which is full of these little squiggles. And I think that is so obviously misspelled. Why didn't you fix it? It just creates a terrible impression. So do that. Or the other thing is, make sure that your paper is consistent in the presentation. Look, I've got a sample document. I refer to it quite often. There's no real magic in it, and many students present papers which are far more polished in terms of their presentation than what I've come up in the sample document. But there are a few basics in that document. The first is there is a consistency in the font, consistency in the size, consistency in the spacing, consistency in the justification. Now, what do I mean by that? If you're presenting a paper, for goodness sake, don't jump between Calabria 11, Calabria 12, and then suddenly it goes back to a 10 font, or for some reason you've thrown in some Times New Roman, and then the whole paper is left justify, and then suddenly for a part of it, it goes to full justification, and then who knows, it was 1.5 spacing and suddenly it's gone to 1, and it just looks awful. It just looks terrible. So before you present your paper, certainly the second paper, why not show it to a friend? Just say, look, does this look presentable? Is this professional? See if they can spot some mistakes and fix it. And if you don't know how to fix it, and I'm not being facetious here, and I'm not trying to be rude, but you really do need to consider doing some program to help you with the basics. Look, I'm not an expert by any means, but I've got a few of the basic ideas, and you need to have that so you can present a professional document that looks the part. Okay, now apart from that, what do we do? I look for a demonstration that the person has understood what they've read. And a very good way to convey that you have understood what you've read is to paraphrase or summarize what has been written about. So if you make a statement properly referenced from legislation or case law and then go on to comment about that in an intelligent way, it tells me that you have understood what you've read. So having that extra little bit of commentary is really important for that purpose. Obviously, we encourage people to read widely. And if you do read widely, for goodness sake, make sure that you reference it in your material. That way I'll know that you've read wisely. And on referencing, you'll understand that because of my training, because of what I do have a strong preference for footnotes. And you'll see that in the case law, you'll see that in the textbooks and the commentaries. There's consistently referencing through footnotes. If you don't know how to use a footnote through the Word program, it's really simple. So find out how to use that. For the most part, people do reference very well. They extract quotations appropriately. That's another thing that I look out for. I'm always keen, of course, to see if the person has identified the real legal issues, what is important, and whether they've drawn appropriate conclusions through their own comments. If you come up with an original or interesting way of doing things, or an interesting idea or an interesting argument, you'll always get credit for that. And that's really where we're talking the difference between a distinction or a high distinction. Some of the things to come up with your own novel argument or approach in words, but maybe it can be a different way. It might be by introducing pictures or graphs or other forms of commentary to really make your paper stand out. Make sure ultimately that whatever conclusion you come to, whether it's right or wrong, is not so important as to whether or not it is well reasoned and it's argued and it's insightful, analysing the appropriate issues. So they're the sorts of things that I look for in an assessment piece. So please keep that in mind when you're doing your second assessment. All right, I've done a lot of talking. Let's talk about tonight's topic, and I won't keep it long, but environmental impact assessment. Already you would have noticed that there is a Zoom session with Phil Jeston, as I mentioned. That's you must watch that. That really provides some eye-opening insight. Secondly, you'll see that there's my session, Zoom session in relation to Chapter 10 of Bates. That's really important chapter 10. And finally, there is tonight's session. So the environmental impact assessment process is one that is sometimes undertaken voluntarily by a proponent for a particular development application, but most often it's required by legislation. And that legislation can be Commonwealth-based or state-based, or sometimes both. So why do we do an environmental impact assessment, apart from the obvious that we're forced to do it by legislation? What's the purpose of it? Ultimately, it is not an end in itself, but it might be described as a means to an end. The aim of the assessment piece is ultimately simply to provide the decision maker with good information, accurate information, so that that assessment manager can make the right decision. Or if the matter is subject to an appeal on a merits appeal, the P&E court judge who deals with the matter can make the right decision. So the primary purpose, of course, given that it's an environmental impact assessment, is to provide a determination or statement as to what are the likely impacts of a proposed development on the environment. But it's not just about environmental issues. It's important that it deals with social aspects as well and cultural issues. bear in mind that what you need to do is present something through this assessment process which will help the decision maker to make a decision according to law. Now, what do I mean by according to law? Well, let's say the assessment manager has to comply with the requirement to consider the development in the context of ecological sustainable development principles. So if we think back to what's involved in ESD, it's not just the environment, but it's also the social, the economic, the cultural as well. So a properly drafted environmental impact assessment will not only deal with just the environment, but it will also deal with those other matters. And it's a way of not just considering what will be the immediate effect of a proposed development, but what are the longer term issues, what is the potential damage, how can that damage be mitigated in the future, how can the situation be monitored into the future. So the EIA, or the EIS which springs from it, should cover all those things. And also part of the process, and this is important, is that the public are involved in that process. They're invited to participate. And the EIA will be guided by what is stated in those terms, which has the input of the public in it. But it's important to understand, as I mentioned before, that this is not a means in itself. It's not an end in itself. It's simply a way to assist the decision maker in coming to the right decision. Now, I mentioned before that the EIA may be required by state law or federal law. Now, here's an important issue. If it's required by both, to avoid a duplication, which could be very expensive, the states and Commonwealth have entered into what are called bilateral agreements. Now, what that means is that if there's an assessment requirement to comply with both jurisdictions, then the federal authorities will allow the work to be undertaken by an accredited state through this bilateral agreement, so that the state will monitor the situation, make a decision. But ultimately, of course, the Commonwealth still has control of the actual decision. So the assessment requirements, the assessment is considered at a state level, but the Commonwealth can come in and make that final decision. We saw that with Traveston Dam, where it was supported at a state level, but the Commonwealth came in and said no to that. Okay, so EIAs deal with a number of issues, can be voluntary, can be imposed, need to be broad, need to think about a number of different issues both now and in the future, and may relate to both Commonwealth or state and may be dealt with through these bilateral agreements. If you have a look at Phil Jeston's video, it provides some eye-opening insight into what these things mean in practice. You know, you look at the chapter 10 of the book and it all sounds very bland. We need an EIA and, you know, et cetera, et cetera. But what does that really mean in practice? Well, it might mean 18 months of somebody's life or a company's life, and it might mean $1 million in terms of preparation cost. Now, think about these issues from a practical perspective. That's a huge investment by the proponent of a development, in both in terms of time and money. The risk associated with those decision-making processes is enormous. So these things are really important, is what I'm trying to say. And that's why I really want you to take a lot of care and really think about the issues in assessment item number 2, which deal a lot with environmental impact statements through the assessment process. Okay, what is important is this. If you are a consultant to a proposed development, to a developer of a proposed development, when it comes to talking about the environmental impact assessment, you need to think about the terms of reference. Now, the terms of reference really sets the scene for what will be prepared down the track. So you've got to get that right. In the terms of reference, you want to talk about the appropriate methodology, you want to talk about the criteria that's going to be used in that assessment process, and you're going to want to do that to some degree collaboratively. So if you're the proponent or advising a proponent in an EIS required development, you might want to engage with the assessment manager at an early stage to assist in the preparation of the terms of reference. You may wish to engage with community groups as well, so that the matter can proceed as efficiently, both in terms of time and money, as possible. Bear in mind, of course, as I've said before, that the public will have a say in these things as well. Okay. When it comes to the EIA, as I said before, it's not going to be the end result, but it will be considered. And you're not, as a proponent or an advisor to a proponent of a development, you're not necessarily just looking for an answer yes to the development. And this is critical, and Phil Jeston talks about this at some length. It really is a matter of determining what are the conditions to the yes. And those conditions will normally be the subject of arguments, which can ultimately go to the Planning and Environment Court. But those conditions can either be reasonably easily satisfied, or they can be very onerous. The conditions can be reasonable or unreasonable. And I'm not necessarily saying that because they're onerous that makes them unreasonable. They might be onerous and reasonable. Conversely, they may be easily satisfied, but even then unreasonable in the context. So it's a matter of balancing how onerous they are versus the reasonableness of those conditions, and that's where many of the arguments in a planning and environment law dispute will be considered. So it's really those conditions which are going to be the subject of arguments, and the conditions can be so tough that the imposition of those conditions is effectively tantamount to a refusal of the application. All right, well, thank you very much for joining us tonight. Next week, I'd like you to read chapters 6 and 10 of Bates. I'd like you, of course, to start considering assessment item number 2. Please collaborate, use UCREW. If you haven't used UCREW, I'd urge you to do so straight away. It's a very valuable resource. If you aren't involved in a study group, do that now. Get to know your fellow students. It's not too late. We've only got a few weeks to go, but now leading up to the second assessment, which is due on the 4th of June, now's a great time to do it. By the way, the assessment on the 4th of June, it will be 11:45 p.m. Ignore the 5 p.m. I'll allow till 11:45 p.m. But if you're late, as always, there will be penalties. And if you need to apply for an extension, you must do it before the due date. I won't accept an application for an extension after the event. Okay, all the best, and we'll see you next week. Bye.